We are here today for an intellectual property considerations for young lawyers CLE called My Client Has an Idea, Now What? And our panelists today are Megan Laudrier, Ricky Bonilla, Melissa Gray, and I'd like to give a little short intro, and then I'm just going to pass it on to the panelists, and they're going to take it away. Megan is a senior associate in the patent group at Baker Botts. Megan is experienced in all areas of patent law, including complex patent litigation, post-grant trials at the USPTO, as well as patent prosecution and counseling. Fun fact, outside of work, Megan is a fitness instructor at Grit Fitness, teaching a body sculpt class once a week. She says it's for fun, but it's pretty intense, just a warning. But you can contact her to try out her class. They are open despite COVID, so you can safely actually go to their class live and not online. Ricky is a litigation principal in the Dallas office of Fish and Richardson, where he serves as the office recruiting principal for Dallas, chair of the firm's Next Gen Initiative, and co-chair of the firm's Hispanic Latinx Affinity Group. His practice focuses on all aspects of intellectual property and commercial litigation, with an emphasis on patent litigation. Fun fact, at 16, Ricky played in a baseball tournament in his native Dominican Republic, where he was hit by a pitch by Neftali Feliz, who went on to be an all-star closer for the Texas Rangers and become the 2010 AL Rookie of the Year, and throw the final pitch in the 2010 ALCS that sent the Rangers to their first ever World Series. Feliz was only 15 or 16 back then, but he threw super hard, and Ricky had a mark for quite a while. But that is his claim to fame, other than his probably 500 batting average for our DAYL softball team. Melissa Gray is a partner at Klimchek LLP, an IP boutique in Dallas. She focuses on IP portfolio enforcement and business and corporate transactions. She brings with her unique in-house experience, having served as corporate counsel, associate general counsel, and interim general counsel at Prime Source Building Products, Inc., the largest manufacturing distributor of building materials in North America, before returning back to private firm practice. Fun fact, in her spare time, Melissa enjoys spending time with her 2 daughters and baking novelty cakes for friends and family. Unfortunately, I didn't ask her to bring pictures, but I'm curious. Before settling in Dallas, she enjoyed solo traveling and has backpacked through more than 20 countries. So I'm gonna pass it off. I think, Melissa, you're starting us off. And welcome, everybody.
Awesome. Thanks, Taylor. Before I turn it over to Melissa, I wanted to give a brief agenda for what we're going to cover today. First, thank you all for being here. We're so excited to go over some intellectual property considerations for you. Our plan today is to start by giving a brief background on various aspects of intellectual property, patents, trademarks, trade secrets, copyright, give a little background, and then spend a lot of time walking through some case studies. So some actual fact patterns where we can go through how you talk to a client, what considerations you want to put in front of the client. So that is our plan for today. If you all have questions, go ahead and use the question answer box. We will be watching the questions. You can address them during the presentation or at the very end. Happy to answer any questions you have. You can also raise your hand and we'll answer your question that way as well. So with that, I will turn it over to Melissa to start us off.
Thank you, Megan. So, hi everybody. This is meant to be sort of an overview. As Megan said, feel free to interject with questions. We're going to hit all the topics on this slide briefly, but we'll probably have some time at the end to dive in a little bit more should anybody need to. To start, we just want to touch on why this is important, because it really is sort of a niche area, but comes into play in a lot of contexts that you wouldn't normally expect. So for clients that you might encounter as a young lawyer, you want to be on the lookout for these issues up front so you can guide them in the right direction. And if it's not in your wheelhouse, get them to somebody whose wheelhouse it is in. But the problem with not being able to identify it is it can cause a lot of issues down the road. So as it says on this slide, IP starts on day one. With any client you have, whether they're a technology company, they're creating a good, they're providing a service, there is some component of intellectual property for that client. So being able to identify what type of intellectual property that might be and how they can protect it in order to leverage it long term and have it turn into an asset for them that they can later use to improve the value of their business is very important. So up front, who are the inventors? Who, will they be a part of the company? What obligations do they have as far as assignment? So if you have a contractor that contributed to the work, making sure that that ownership of title is clear. Do they have the permission to copyright or get firm protection of that work with respect to a trademark or a patent or a copyright? And there is, particularly in the trade secret space, this idea that, whether you disclose it or not, the avenues of patent, trademark, and copyright, they're public records. So you have to know that going forward, that these works will be disclosed publicly, and whether you advise your client to do that or not is something that you need to think about up front. And I know Ricky had some firsthand comments on that too, because in the patent space and the trade secret space, there is a difference on whether you want to advise your client one way or the other. Ricky?
Thanks, Melissa. Yeah, so what I wanted to point out here is just how crucially important it is for getting that scope correct. And by scope, I mean, how much do we disclose and in what manner do we disclose it? Because if you take the wrong IP, say you try to get a patent for an idea or an invention that was more properly a copyright, you may spend a lot of money in not ever get that patent or to see it quickly invalidated in court. So the tension that Melissa pointed out of how much do we disclose, when do we disclose it, is crucially important to get right from the outset. You really want to know what your client's long-term strategy is, what they're looking for, what they want to get out of this. And we'll talk about a little bit more as we get into the specifics of these various types of IP. But the number one question you want to know from the beginning is, what is it you want to do with this particular intellectual property? What is it you want to protect, and how long do you want to protect it for?
Melissa, you're still on mute.
Unmute.
Yeah.
Great point, Ricky. Thank you. And with that being said, in all these discussions, you want to be mindful of initiating in those talks without a non-disclosure agreement, and whether it's the right context to have a non-disclosure agreement with the people that your client is potentially engaging with long-term. So just some things to consider before we dive into the specific types of intellectual property. But with that, I think we're going to dive into sort of my neck of the woods. Strategies. First, as Ricky said, have an IP strategy, know the scope. It can really reduce risk for your client to know upfront that they have considered these things as property, they have done the right thing. That is absolutely what investors want to see, that you've trademarked, patented, or copyrighted your works. They don't want to have to do that at the end. And by doing all of those things up front and having a plan in place, you can really set yourself up for success and have them be an asset. If you don't feel comfortable, seek somebody's advice that has that background, because it can become a hindrance instead of an asset if not handled properly. So I think with that, we'll dive into trademarks. So Probably the most forward-facing of the IP and things that you encounter on an everyday basis are trademarks. They're all over the place. Billboards. A trademark is really just a source identifier for a product or service. It can be a word, a symbol, a slogan. We've got some listed here. Others, you know, you're bombarded with them on a daily basis. So some that you might not think about are also sounds, you know, jingles, that kind of thing. So there's definitely, if you can call to mind a company or a service, it can most likely be a trademark. So trade dress is just a form of trademark protection. I've listed a few here. I'm sure you all can guess just from these photos the companies that they're associated with, and that is the absolute point of it all, that these images call to mind a specific company. So you've got your Tiffany blue box, you've got your Converse shoe, which is actually the subject of a couple litigations right now by Skechers and Walmart. So that one's kind of up in the air, but it was registered for a long time. The Jack Daniels bottle, the Coca-Cola bottle, and then your Louis Vuitton red sole, which are all source identifiers for those respective companies and can be anything: size, shape, color, texture, and really also add value to the portfolio of these companies and their lineup of goods. So a few things about trademarks. You don't necessarily have to register it. The first to use it wins, but registration enables you to have nationwide rights as long as you're using the mark in commerce, and it can last forever. So as long as your client continues to use the mark, they can maintain those rights for as long as they continue using it. If they have a period where they stop, that's longer than 3 years, they can abandon those rights, and that can be a problem. So the best marks are those that are unique. You know, they're not your corner store, they're Google. Nobody has a reason to use the word Google because it's a made-up word. So when your client comes to you and they say, I have an idea for a business name, and they tell you that it's Mike's Hardware Store, that's probably not a good idea because that's not very unique. So guiding them in the right direction as to what could be considered a trademark is half of the advice sometimes, and how they use it in their marketing materials is also really important. You don't want to become the Kleenex, which, you know, they were one of the first to come out with the tissue, but they called it a Kleenex. And if it becomes used as a noun as opposed to an adjective, it can really be detrimental for the way that it's used. Same thing happened to Band-Aid, and you just really want to guide them in their marketing materials and branding to use the mark properly in order to have the highest and best protection for their name. A lot of this today, just because of the rise in web and social media and everything else, domain names are driving a lot of what people choose to be marks. So that is a big consideration. I see clients also coming with, is like, is the domain even available for me to have the name I really want? And if it's not, they usually pivot and go in another direction so they can obtain a website. So just something to consider when they're in the startup phase as well. This is just a nice little visual of the continuum of generic all the way to arbitrary names. So on the right, with arbitrary or fanciful, you would have your Googles or your Geico, for example. On the left, you'd have your corner store, which is entitled to absolutely zero protection. If you filed that, at the USPTO, they would deny your application. In the middle, you've got probably your Best Buys. It's a store, you're buying things at it, but it's sort of suggestive of what you get. You don't immediately think TVs when you hear the word Best Buy, but you know that you're going to go there and you're going to purchase things. Two people can register the same mark in connection with different goods and services. So you should know that by filing, they're not getting blanket rights to use that name in connection with every single thing. Your client is going to have protection in connection with exactly what they're using it for. And you see this regularly in the market. You have Delta Airlines and you have Delta Faucets. So just a lot of clients may have the expectation that no one can use it in connection with anything, and that's not true. So just be proactive about searching up front, even if you start with a Google search for your client. Just look, and if you see a lot of stuff out there, it might not be clear for you to move forward. And you'd be surprised how many people don't do that, and they come to us, and it's immediately apparent that that's going to be problematic. And once you think you have a clear path, there are more in-depth searches that you can do that really can give you the comfort that you would need for your client to invest in that name and begin marketing and creating materials that can help them sort of catapult their business and use that mark long term. So I'm going to turn it over to Ricky for trade secrets.
Yeah, so when we're talking about a trade secret, that's very different from what Melissa was just talking about, right? Trademarks are very forward facing. It's something that the public sees and then attributes to a particular vendor or service or good, whatever it may be. Trade secrets is something that by its very name, obviously it's a secret. It's something that you keep confidential. And so we're going to talk for a moment about what a trade secret is, how you maintain a trade secret, and why they matter. So what is a trade secret? A trade secret, as it says here on the slide, is basically any information that is valuable because it gives you an advantage in the marketplace. Or an easier way to put that is, it's any information that is valuable because it's secret. The fact that it is maintained as a secret is what gives it its value. So these are things like customer lists, vendor lists. It can be technical information like source code. It can be the names and addresses of employees, for example. It's something that you want to maintain away from the public eye. And because you do that, it has value. So the example here on this slide, it's a little difficult to read, but that is someone's attempt at the basically Coca-Cola recipe, which is probably the most famous trade secret because they maintained it as a trade secret for a very long time. And the reason that it's valuable is because nobody knows exactly how to make Coca-Cola. They've kept it as a secret. So if we go to the next slide, we'll talk a little bit about how you maintain it. And really the way that you do it is just take the reasonable steps, reasonable efforts to maintain this information secret. So you can do that by restricting physical access to certain places, right? You have badges, or if there's guards, you put things in the safe. You maintain agreements. We've heard from Melissa about non-disclosure agreements, for example. So you can have non-disclosure agreements with your employees. You can have non-compete clauses in agreements with employees to ensure that the information that they learn while working for you does not then end up in a competitor's hands, and definitely does not end up in the public space. It's also how you maintain the information. So a lot of times, we work a lot. I work a lot with patents. You've got lab notebooks or inventor notebooks where the inventor maintains a lot of information that's very crucial to their conception, their invention. You can also keep logs of people who see the information, can maintain formal procedures. You can have written processes for how information is going to be handled within your company or in your business to ensure that the level of secrecy is maintained the way that it needs to be done. And then also, of course, because we have, live in the world that we do, there's computer aids. You can have restrictions, passwords. There's a lot of different ways you can maintain a trade secret as a secret. But the most important thing is that you make, and the legal test is reasonable efforts to keep it a secret. As long as you do that, you have a trade secret. So why is that important? It's important because trade secrets, as I mentioned earlier, last forever. So anything that's confidential, it's not generally known, that could be a trade secret. And that makes it the opposite of, for example, patents, right? A patent is a limited monopoly. The patent holder gets 20 years, basically. That's not true for trade secrets. As long as you maintain it as a secret, it will continue to be a trade secret and a valuable piece of intellectual property for your client. Now, another interesting part of a trade secret is that in order for it to be misappropriated, so when somebody takes a trade secret and you can infringe on a patent or infringe on a trademark, when it comes to trade secrets, it's misappropriation. So you have committed some crime, the bad actor has committed a crime or breached some kind of agreement to obtain the information. If somebody were, for example, to reverse engineer, if you were to take Coca-Cola, take a sip of it, and then write down the recipe because you just figured out exactly what it is, you haven't misappropriated anything. You haven't broken any laws. You haven't breached any agreements, assuming, of course, that you don't work for Coca-Cola and have an employment agreement that requires you not to do this. So if you can reverse engineer a trade secret, you can find out how the trade secret operates. You can then make it your own trade secret. It is possible to reverse engineer trade secrets and then keep the information you learned from that reverse engineering as your own trade secret, as long as you take the reasonable efforts to keep it a secret. And the fact that it is a secret gives it value. So one of the things that we've heard from Melissa, and I'm going to let her speak in a moment to this in particular, is NDAs, non-disclosure agreements. They're huge, a part of mergers, of discussions, of just any kind of discussion between parties about things that they consider to be valuable. Because if you've got that NDA, that is a reasonable effort to ensure that just because I told party B that I have not actually given away my trade secret, I'm still maintaining it within a pretty tight group, and I'm taking those reasonable efforts. So a lot of times just the negotiation of the extent of an NDA will take up a huge part of some discussion between two parties, because they both want to make sure that their trade secrets are being safe one from the other. And I think Melissa had a particular point to make on this NDA question in particular.
Yeah, actually, Ricky, that was me. I wanted to share a story with everybody.
So I thank you, Megan.
No, it's okay. ML, MG, we put our little notes in there.
I see ML and I think Melissa. I'm sorry.
That's fair. That's fair. But no, I had a story to share for a client just about NDAs and the difficulty with that. So my client was actually, had filed a patent, hadn't been issued yet, but was trying to get, this other company to buy into his idea. And this company was asking a ton of information, very, very specifics. And he kind of paused and said, maybe we want to sign an NDA, which was very smart for him to pause there. But this big company just kind of stopped talking to him and was just like, we don't need you, and actually ended up signing a deal with someone else. So advice there, and a way that you can get involved and help your clients, is negotiating the NDA, like stepping in and trying to make it friendly and, hey, we're just trying to protect your ideas as well as ours. Make it, like Ricky said, mutually beneficial, and just make sure that that doesn't get in the way of any sort of business deal. It absolutely can sometimes, but a lot of times if you as their attorney can step in and try to help the other side see that it's beneficial for them as well, it could be good in maintaining everybody's trade secrets.
And one last point that I'll make is that it's crucially important that you educate the people who are involved with this trade secret as to the steps you're taking. Why is it important? Why is it a secret? And how are we keeping it a secret? I have had situations where clients have, an engineer who comes and writes a piece of code that gets implemented in a particular product. That person then moves on to another place. And when they move on, they think, well, I wrote the code over there. It's my code. I can use it here. And they plug that code into somebody else's product. You can't do that. That person very likely had an employment agreement that required that anything that they did while on behalf of the company, that it stayed with the company's intellectual property. And that is not necessarily something that's intuitive to people, where they will think, hey, I wrote that, or I came up with that, or I made this, so I should be able to use it in my further employment or in my career later on. So it is really important, as we noted earlier in the presentation, that you educate everybody involved on why this is important and how we're going to continue to make it a secret. That's part of the reasonable efforts that you need to take in order to ensure that you keep your intellectual property yours.
And Ricky, if I could just, when I was in-house, that was something the company really didn't have when the legal department was formed. So what we ended up doing was scheduling out generally what they considered to be trade secrets. So there was no question for the executive team, and everybody was on the same page. And then they were also reiterated in those non-compete agreements with the employees down the road. So that's just a practical example of sort of how you might identify them and educate your leaders on what they are. Oh, and this is me too. Okay. Diving right in, copyrights. They are authors' fixed expressions in tangible media. What does that mean? That can be everything that comes to mind when you hear it. You've got your books, your songs, your plays, your paintings, pretty much the artistic elements. The copyrights themselves are on very simple forms. It is not easy to deal with the Copyright Office, but it's easy to file an application and it's very inexpensive. There's no, unlike the patent process and the trademark process, there's no examination either, which is beneficial for anybody who's filed a trademark or a patent. It can take 2 years. The Copyright Office, I mean, it might take a year, but that's not because they're sending it back to you. That's just because they're backlogged and that place is not showing signs of improvement anytime soon, actually, either. So you have to obtain a registration before enforcing it, but it is another avenue beyond trademarks and patents that you can go to preserve rights in your work. So copyrights, and you'll notice, especially in the age of social media, people copy and paste things all the time. And there's this idea of fair use of things that are out there in the world. And the defenses to copyrights come up quite a bit. So if you didn't have access to a work, the elements of the work are unprotected, or you used it, just as a comment or a parody. There's elements to whether something is considered to be fair use that sort of go to the totality of the circumstances, just like the DuPont factors in the trademark space. But at the end of the day, if you change the work, then you're probably okay. But if you directly copy it for your own commercial benefit, or even not commercial, just for disseminating it to the public, that is a violation of somebody's copyright. So there's two examples here that are really coming up more. There's this concept of open source software in the technology space, and the rise of sort of the copyright troll in social media. So we'll touch on the open source just briefly, but the source code, you still get a license to the source code, and you have to pay attention to what that license says. So if your client is creating something based on open source and they modify and change it, sometimes it says then they have to republish it for the rest of the world to use again. Sometimes it says they have to republish it and then charge a fee. So you have to know up front what kind of code they're using, what the limitations are of that code, and then be able to advise them down the line of what that means. So pay attention to the license for the code at the beginning is really the main takeaway here. And what you don't want to do is destroy their software or unwittingly violate, the reps and warranties that you agree to when you use the code. So copyrights are inexpensive. There's limitations though, in that they only stop direct copies. Just like if you reverse engineer it, it's yours. Like if you change a work enough, then that can be your work. So all these artists that, if you do a drawing of a picture or you change something and it is truly your artistic work, that is a defense to copyright infringement. And then the caution here, don't mix open source with proprietary software, because that's just bad news.
Awesome. Thanks, Melissa. So last general overview we're going to talk about today is patents, and then we're going to dive into our case summaries. So that'll be a fun experience for us to talk through how to counsel your client on various issues. So patents. Basically, a patent, Ricky mentioned this, it's a trade-off. So you publicly disclose your idea in exchange for a monopoly of 20 years. So you disclose the idea, you file a patent, it stays secret for 18 months and then is published. But ideally you'd go back and forth with the patent office and then receive a patent. But you only have 20 years to exclude everyone else from using it. And that's a main idea that I really want to get across here, is that patents are offensive, right? Not defensive. So you can prevent someone else from using your idea, but it doesn't give you necessary permission to use it exclusively. So if I have a patent on something and I see that Ricky's using it, I can sue him for patent infringement. It's a sword, not a shield. So make sure that's comes up a lot in patent law, that it's only offensive rights. So who deserves a patent? Typically, in patent law, you have to prove that it's useful, novel, or new, and non-obvious. So useful, it has to have an actual use, it's pretty low bar. Novel is the one that people generally focus on. So it has to be new, and that's an easy way to explain it to, for example, to your clients. If this has been known for 30 years and if you're making a doohickey and everyone knows how to make it, it's published in all the college textbooks, you're not gonna get a patent on it. But if you have an aspect of it that's really new, you can get a patent on that new aspect of it. So it has to be new. What's new here? What's the new idea that you're coming up with that we want to protect? And then non-obviousness is a non-trivial advance. So a good example here is, okay, let's say that I invented a doorknob. And in my patent, I said that the doorknob is made out of brass. And then someone else tries to file a patent and says, oh, well, I'm going to make the exact same doorknob, the exact same shape, but I'm going to use a different material. That may be an example where it's a pretty obvious change. So you may not get a patent there. Generally a relatively low hurdle. And I think most people focus on the new aspect. What's new, what's novel here. So parts of a patent. If no one's seen a patent before, here's an example of an old patent. So this is the cover of it. You have United States patent, you have the patent number, the date that it was patented, a little brief abstract, and figures. So big picture, a patent includes figures and drawings and claims. So here's an example of figures. This is like a hair tie patent. It's very old, back from the 90s. But it shows these figures and different aspects are marked. And then on the right side, it has a detailed description. So that's where you go through and say in figure 1, there's part 10, 18, 16, 12, 14. These are what these parts are. This is how they work together. You're basically disclosing everything about your idea, how it works, how to use it, examples of how to use it. And then at the very end of the patent, you have the claims. So these are typically very legalese. If you just pick up a patent and read it, it might not make a lot of sense if you just read the claims. But this is the important part. This is what you're actually protecting. So in explaining this to your clients, the claims are really like the recipe here. And so when you have a recipe that you're making a cake, like for example, one of Melissa's delicious cakes, there's a checklist of things that she does to make that cake. So in a patent, you could have a process of steps. You could have a an actual product with a bunch of different parts, but you basically have a checklist for what someone has to do for you to sue them for patent infringement. So if you have step A, B, C, and D in your patent, and they're not doing step C, they're not infringing your patent. But that's where a lot of the technical detail gets in, and a lot of, well, what does this word mean? What does that word mean? What does it mean to be doing step C, et cetera? So the claims are really often where patent attorneys spend most of their time in figuring out, one, how to write it correctly, so you're protecting the right thing, and two, when you potentially go after someone for infringing your patent, whether they're doing that aspect too. So high level, patent goes over figures, specification where you're explaining the figures, and then the claims, which is what you're legally protecting. Quickly, prosecution of an application, when you file it to the patent office, it usually takes the patent office about 2 years to get to you. The attorneys then argue with the patent office regarding the scope. So sometimes the patent office will, say, hey, your idea is not new. Here's some other patents that already disclose your idea. You can't have a patent. And then actually, my idea is a little bit different than the stuff that you explained is already known. My idea does X and these don't disclose X. So you have a little back and forth. And sometimes it's really helpful to have your inventor input and explain some of the prior and explain to you what's different here. So high level overview on patents. If you're explaining this to one of your clients or someone who's considering it, like I mentioned, patents are bullets, they're swords, not shields. So they allow you to sue someone for patent infringement, but don't necessarily protect you in what you're doing. They take a lot of time to acquire, sometimes 2 to 5 years. It holds your place in line, but you don't always have an issued patent right away. Usually takes some time. Patents are also very expensive. You have to pay fees to the patent office. You have to pay, once you have a patent, fees to maintain the patent, fees for the attorney to draft the patent, which can take some time. And then also if you want to protect it around the world, not just the United States, foreign filing fees are very expensive as well. And often you want to consider for your client too, maybe something is patentable, maybe you can get a patent on it, but is it catchable? Can you figure out who's infringing your patent? Do you, can you figure that out through the product that they're selling, or do you have to be able to see inside their lab? How are you going to figure out who you want to potentially sue for patent infringement? And Melissa mentioned this at the beginning, but you either need a patent portfolio or a reason why you don't have one. So IP starts on day one. Maybe a reason, like Ricky talked about, maybe everything is secret and it's going to last for more than 20 years of a patent. So you don't have a patent portfolio because you have a million trade secrets. That's great. But you want to make sure that you're starting from day one and considering, okay, do we want a patent? If not, what's our reason for not having a patent? And also patents have big value even if you're not suing people. So a lot of companies have this huge portfolio of patents, which are big assets. You can sell them. You can license them to other companies to allow them to use your patent. It looks good if you ever want to sell your company. So even if you're not going to go out and sue everybody, having a patent gives you a lot of different options in ways of making money and also protecting yourself. And so with that, we finished our patent overview, we finished our trade secret overview, copyright overview, and trademark overview. So what we're going to do now is go through a case study. So we have 3 case studies that we'll go through. I will read this first one and then talk to you about how I potentially talked to my client about this. And Melissa and Ricky are going to chime in as well. So case study number 1, new idea, patent or trade secret. So your client, Tom Edison, calls you about a brilliant idea he has for a new kind of light bulb that he is calling new light bulb. He hasn't told anyone about the idea and expects it will be a key technology for a long time. If he can keep his competitors from using this technology, he will have a huge competitive advantage. So, the new light bulb is key to his competitive advantage and name recognition in the marketplace. So what advice do you give Tom and how do you walk him through it? So in starting off, we kind of set this up in that, should we file a patent or a trade secret or try to protect it as a trade secret? So first I would get a little bit more information from Tom. So he mentioned that he has this brilliant idea he hasn't told anyone. That's a great start, hasn't told anyone. You want to keep it secret either way. So he said he expects it will be a key technology for a long time. We talked about trade secrets being lasting for as long as they're kept secret, whereas patents only are giving you rights for 20 years. So I would ask Tom, I'd say, okay, how long do you expect this to be a key technology? 5 years, 10 years, 20 years, 50 years? And if it's on the longer edge, then that kind of shifts it more towards protecting it as a trade secret rather than a patent. If he says 15 years, anything below 20, maybe a patent is a better idea. Another aspect, so if he can keep his competitors from using this technology, he'll have an advantage. Think about the new light bulb. So if he creates it and sells it, will someone be able to reverse engineer it? So if we're protecting it as a trade secret and then we sell the light bulb and all of his competitors can reverse engineer it, like Ricky mentioned, that's not misappropriating a trade secret. It's a reverse engineer. So if they'll be able to figure it out from the new light bulb, maybe that leans more towards the patent. Because if they, if I tell the patent office, hey, here's my idea, everyone's going to know how to do it, but they're not allowed to because I have a patent on it. Tom Edison has a patent on it. So those are a couple of the initial questions that I would want to ask. Ricky, did you have anything to add on the patent versus trade secret aspect?
Yeah, so I think you keyed in on a couple of things that are really important. So he says he expects it to be a key technology for a long time, and keeping it from his competitors gives him a competitive advantage. That sounds like a trade secret. But then you want to ask, what actually is this idea? What is this new thing that you're doing? Is it the process of creating the light bulb? People probably aren't going to see that. So maybe that's something you want to go a trade secret route. Or is it the actual material that the bulb is made out of? Is it the filament that goes into the bulb itself? How easy, as you noted, would it be to reverse engineer this? And I think if you were looking at something that is going to be tangible, that I can take and walk out with of a store, that's more likely to be reverse engineered and probably leans you towards a patent. But if you're saying, I have a new process for how I create this light bulb, now you can also patent the process, of course, but if it's a process that's going to be done behind closed doors and you're going to be producing bulbs, maybe you want to keep that process a trade secret, and maybe you want to do both. Maybe you want to keep the process of creating the light bulb a trade secret, but then patent the bulb itself, which is certainly something that you could do. So you really want to get into the details of what exactly is it that you think is new. And actually, if you're advising your client, even better, just have him tell you what he's come up with, and then let you figure out what are the kinds of questions you need to ask to guide them to the right way. It might be a patent, it might be a trade secret, it could be both.
Awesome, thanks, Ricky. And Melissa, I wanted to bring you into on the trademark aspect of this. So Tom Edison said the name new light bulb is key to his competitive advantage. What do you think about potentially getting a trademark on that? And make sure you take yourself off mute.
So that's a phrase you might hear a lot. It's not always true because it sounds like a pretty descriptive name. Back to sort of the continuum on the slides at the beginning, it's not quite generic, but borderline, because he created a new light bulb. So he's describing his product. So even though he's taken out the spaces and sort of made it one word, it would still be problematic. Obviously, with both the patent and the trademark side, you'd want to start your conversation, if they're very insistent, by doing a search, and that might give you some leverage too in advising the client, like, this is off limits, or listen, the people have tried this before and been rejected for this very thing. In terms of, you always want to steer them towards something unique, and that would be my advice here.
Awesome, thank you. And Ricky, I know you had one more fun fact about this case study.
I did. If this case study actually were to happen to you in real life, that would mean that your name was Frederick Fish, because Thomas Edison's patent attorney was Fred Fish, who founded Fish and Richardson. I know that's a real summer associate, like, cliche thing to say, but I just think it's a really cool fact.
I love it. I thought it was a fun fact when I first heard it. Awesome. So I think we walked through the issues, but takeaways here: make sure you dive in with your client and ask them the right questions. You don't have to give them advice right away on, oh, the right answer is patent. Oh, the right answer is trade secret. You know, walk them through it. Explain to them the considerations of both, and that'll definitely help your client trust you and also make sure that you're giving them the right advice. So let's go to case study 2. So Melissa, do you want to take over this one?
Sure. So this is another one with really unique name. Client sells a product called Ultra Awesome Sticky Tape for use in connection with tape that is sticky. This is very actually close to something that has walked through the doors of every law firm, I guarantee it. Client's been using the name in Texas since 2014 and sells at a local Ace Hardware store, but never filed any trademarks. The client now finds out there's a competitor on the market selling under Awesome Sticky Tape, and that they have filed a U.S. trademark application claiming use back to 2018. He's also had customers calling him to complain about Awesome Sticky Tape and demand their money back and post negative product reviews online. What do you tell your client? So there's a lot going on here. You probably wish you would have caught your client back in 2014 to steer them away from the Ultra Awesome Sticky Tape name, but you get what you get when they sort of come through your door, right? So the facts being what they are, he's in a little bit of a predicament because he has never filed a federal trademark application. So his rights are going to be limited to the geographic area in which he sells this product because he's never filed. That being said, if he has a competitor out there in the market that is creating confusion, and this is actual confusion under this hypothetical, that is a very good fact for him to object. And since they've had a registration for coming up on 2 years, his avenue to do that would be to file a petition with the Trademark Trial and Appeal Board to cancel the mark, or a lawsuit, a federal lawsuit claiming trademark infringement. So if he has a concern, which I think everybody could agree, especially with the actual confusion occurring, that Awesome Sticky Tape and Ultra Awesome Sticky Tape would be confusing in the market for just an average consumer. They're selling the exact same good, and they are in the same market. So you really this is going to be a conversation about enforcement, and then you probably need to circle back on, hey, are we able to get any protections for you in the trademark space too? Maybe go on the defensive and file a federal trademark application yourself, claiming use back to 2014, and kind of get those strategic filings in place as you continue down a litigation path. But I know, Ricky, you had another angle too.
Yeah, so I actually have a question for you that can kind of inform my angle.
Yeah.
What if this was a little bit different and they both wanted to use Ultra Awesome Sticky Tape and they started using it around the same time? Who would have the better claim to it?
So, I mean, first use, right? So you're getting down to the wire, and I've actually had filings within days of one another inform whose rights, who has prior rights in those marks. So that is an incumbent upon your client to keep good records of when they begin using these marks, when they have their advertisements out in commerce, and they've got their sales being made, because those documents, especially if you're in a contentious sort of race to see who was first, are going to come, to the forefront and be scrutinized a great deal. So it really depends on who's first. Now, that being said, there is this concept of, well, but I spent $3 million in advertising and you spent $3,000 in advertising. And then over time, that can play into the factors of whether these, one has superseded the other in terms of rights. But the first and most compelling fact is going to be timing and who was first.
So the reason I wanted to ask that question is because I think it's a good comparison to make with patent law. So before 2013, it would have been very similar in a patent situation where if you had one person invent ultra awesome sticky tape and another person invent the same thing, and they both filed around the same time, the question at that time would have been who invented it first. You would have the opportunity for one of them to show I conceived of this invention first, and therefore I have the right to it. But in 2013, the U.S. instituted the America Invents Act and changed the law to the first to file. So if you got two people who invent the thing same time, the first one to file an application now has the right and the priority to that patent. And that actually brought us in line with the way the rest of the world was. Most of the rest of the world that had patent laws were first to file systems. We were first to invent up until about 7 years ago. So I think it's interesting to see, like with trademark, it's the first to use, so you've got to keep all those records. Certainly, you want to advise your clients that if they're going to go the patent route, they should also keep those records. It's always important to have this kind of written information. But it's really going to be crucial to get that filing done first, because if you're the first to file, you're going to be the one to get the patent the way the law is today.
Awesome. Really good point, Ricky. And thanks for walking us through that, Melissa. Before we go to our third and final case study, I want to remind everyone about the question and answer. So if anyone has a question, go ahead and start filling that out now, and we will have time to address it at the end. So if you guys, anything's popped up, feel free to type that in and we will address it. Wanted to remind you of that. So case study 3, Ricky, take it away.
Okay, so catering placemats, patents or copyright. So you've got a client, set designer, and they're in the theater business. They are well sought after because they're uniquely adept at food presentation in theatrical productions. Their productions include food scenes that always have tables set up to present the food options in the most enticing and sometimes logical manner. What's their secret weapon? They have large tablecloths with instructions for where and how to present each food item. So set designer calls you and wants to protect the business and has come to ask, can I patent this idea? The answer to the question, can I patent this idea, is almost always no, you cannot patent that idea for a lot of reasons. As Megan pointed out earlier, it's got to be new, it's got to be non-obvious. If it's a utility patent, it's got to be useful. And especially when you say, can I patent this idea? Because ideas start falling into an area of patents where you start talking about the eligibility of a patent. And that's kind of a threshold issue. And the easiest way to describe it is think of Albert Einstein and E = mc², right? Brilliant, obviously, very useful, obviously, not obvious before he came up with it, but you can't patent that. It's a natural phenomenon. It could potentially be an abstract idea. It's something that is the basic tools of science or technology that we don't want to give an inventor a limited monopoly on. If you can come up with a useful and limited way of using E = mc², that might be patentable, but the idea itself is not. So here, you've got somebody who wants to try to patent the idea of using large tablecloths with instructions on where and how to present each food item. That's probably not patentable. That sounds like an abstract idea. Now, the way that they create the tablecloths perhaps might be something that could be patented. Perhaps the fabric of the tablecloth itself, or the kind of ink that's used to stay on the tablecloth, could be patented, but just this idea probably isn't. However, then you can think about copyright. I mean, once they've put these tablecloths, once they've drawn these figures, these information onto the tablecloth, that is now in a tangible medium. And it is something that could potentially be, you could have copyright protection for, especially if you have several of them, right? This is a good scene for a living room, or this is a good scene for a kitchen, whatever it might be. You may have several of them, and it would be possible to get copyright protection, and that might be the way to go. That would be different from going the patent route, which is still an option, but just based on these limited facts, isn't likely to be the best option. What do you guys think?
I think that makes a lot of sense. I think a lot of people are just say that all the time. Can I patent this idea? Probably not. But no matter what the idea is, there's usually one avenue or the other to take in IP law.
Yeah. And breaking it down to like the various steps involved in the process. I mean, there's a lot of different potential touch points along the way that, you know, you can point them in the right direction to. But I think it's copyright is definitely a viable option in this fact pattern. We did have a question come up, Ricky, on trade secrets. So the question is, if a trade secret becomes public knowledge despite your reasonable efforts, what happens next? Is the only remedy to just keep suing people? If you don't sue people, do you lose your trade secret protection?
So that's an interesting question. If the trade secret becomes knowledge despite your reasonable efforts, you got to start filing lawsuits. You got to do something. I mean, taking the steps to protect your trade secret once it's out in public is part of your reasonable efforts. If you just allow folks to use information that got out into the public, after a certain amount of time, the response that you're going to see from the legal field is going to be, well, I mean, you knew it was out there, you knew that people had access to it, and you didn't take any further steps to protect it, right? You can reach out and talk to people to get them, either get them under an NDA, pull down the trade secret information that's been made publicly available. You can start taking those steps. Eventually, one of the reasonable efforts you have to make is to actually pursue them for misappropriation of your trade secret. Now, keep in mind, the actor that you pursue has to have actually misappropriated. So if your trade secret becomes public knowledge, despite your reasonable efforts, somebody went against your reasonable efforts. If you've got NDAs in place, employment agreements, all those things, somebody took that step, and that somebody you really need to find, because that's the person who misappropriated the trade secret and is the one that you're going to need to shut down so that you can continue that protection. But eventually, you would lose trade secret protection if you didn't do anything about it.
Awesome. Thanks for that. We have one more question in the box that we'll address and then let Taylor wrap us up. But so the second question, how often have you seen cost be a deciding factor for clients when deciding what and how to protect an idea? So, so my initial reaction is it is a consideration. Like we mentioned, patents are expensive, copyrights are cheap, trademarks can take some time, trade secrets, you know, you don't have to file anything, but it may cost money to keep it protected. So I think it's often a factor. It's maybe not always a deciding factor, because if my recommendation to a client is the best way to protect your idea is a patent, that is expensive, here are different options you can have. So just walking them through the different options and saying, if cost is a prohibiting factor, here are other options. I think generally though, and Melissa and Ricky, I'd like to hear your opinion too. Cost usually isn't a deciding factor for a single idea, a single aspect that you want to protect through IP. What do you guys think?
So my reaction to when I saw that question, my answer was every day. It's always it's the discussion we're going to have every time. Of course, the question is then, who are you talking to as your client? Is this, is it a Google, a Samsung, a Microsoft? Not going to be as important. Is it, a solo inventor or sole proprietorship? Then it's going to be significantly more important, but it is always part of the conversation.
I agree. And particularly on the trademark side, people, they want that protection, but they don't always realize the length of time and the expenses involved in it. So when they hear that the dollar amount, sometimes they shy away, but at the end of the day, they have to, counseling them on why that investment is going to pay off long term and give them a return on all of the investment that they're making in their brand or in their product. You can usually get them comfortable with it if they're serious, about what they're doing. So.
Awesome. I think that's all the questions we have. Taylor, do you want to wrap us up?
Sure. So I just want to remind everyone the course number is in the Zoom chat at the bottom of your screen. It is 174095543. And also, if you are joining us via the web, you can raise your hand and we can let you in via video to ask a question if you have any interest in doing that. We'll wait around 15 seconds or so and see if anyone raises their hand in order to ask a question. Other than that, we are done. So I really want to thank everyone for joining us today, and I want to thank our panelists, Melissa, Megan, and Ricky. It was really great CLE. It was very informative for those of us that don't do anything with patent or trademarks. And I hope that our attendees got a lot out of it. Sherry, can you let us know if any hands are raised?
I don't see any.
Okay. Well, then I just want to say thank you again from the CLE committee and all of DAYL. We really appreciate the time that you put into preparing this for us and for presenting to us. So we hope to see you again in another CLE next year.
Thanks, everybody.
Awesome. Thanks, Taylor. Thanks, everybody.
Thanks for having us.
Bye.